All right. Good afternoon, everyone. The record will reflect the presence of counsel, the defendant, and the jury. Mr. Barker, you may proceed.
Thank you. Good afternoon, Lisa. Before the break, we were talking about the last report you authored, which was in June of 2020. Is that right?
Yes, I believe it was June 4th.
All right. Do you have that report up there still, or did we take that back?
The papers were taken back.
You may.
Yes, it is.
Just to be clear, what date was it that you authored that report?
It is dated June 4th of 2020.
Okay. And we had talked before lunch, you received a rifle. It was submitted to you, and then you also had that evidence bullet that you looked at earlier, right?
Yes.
And I think you had already talked about you had fired test rounds through that rifle. Is that true?
Yes, I did a test firing of that firearm.
Okay. And the class characteristics, I think we were just on that topic before lunch. Tell us about that.
That's right. When I examined the firearm, I saw that it was a .22 long rifle caliber rifle, and the rifling in that barrel was 16 right. 16 lands and grooves with the right hand twist.
And that was consistent with the test bullet you had examined a couple months prior.
I believe you mean with the evidence bullet, but yes, it was.
Sorry, yeah, the evidence bullet, thank you. Now, you mentioned an organization or association, AFTI, and is that kind of the major firearm and tool mark examiner organization out there?
As far as I know, AFTI, which again is for the Association of Firearm and Tool Mark Examiners, is the primary association that's geared toward firearm and tool mark identification solely.
And do they set forth certain criteria about when you can identify something, when you can exclude something?
They have guidelines and recommendations of the types of wording to be used and, generally speaking, what an identification is based on. They also have procedures to follow for different types of examinations as well.
And for an identification specifically, do they specify how many individual characteristics must be shown?
No, they don't.
All right. And so is that left to the examiner?
Yes, it's going to be based on the examiner's knowledge and experience and the examiner's opinion of seeing sufficient agreement of the markings that we look at and look for.
And so we've identified there's an identification. That's one conclusion you could reach, right?
Yes.
Elimination, is that another conclusion?
Yes, that is.
And that means what?
An elimination would be made if the evidence or the firearm to the fired evidence had different class characteristics. So for instance, if the firearm submitted had been .32 caliber, on class characteristics, I could say that gun did not fire my evidence bullet, item 32. If the gun submitted were a .22 caliber, but had rifling of 6 right, again, I could eliminate that based on the class characteristics. A 6 right firearm cannot fire a bullet that has 16 lands and grooves with a right twist. Eliminations could also be made on individual characteristics. In that situation, the class characteristics would be the same, but the examiner would have to see an overwhelming and an overwhelming and unexplainable difference in the individual characteristics that they would be able to say, based on the difference in individual, this gun did not fire this bullet. And I had mentioned earlier about verifications, the identifications we make, and then the eliminations based on individual characteristics, both have to be verified by another examiner.
All right, so we have identification, we have elimination. Is there something in the middle?
Yes.
What's that?
In between would be inconclusive. And we actually have, if you want to call them different ranges of inconclusive, I guess that would be fair to say.
Yeah, can you describe those?
Under inconclusive, depending on what I see through the microscope and in doing my comparison work, I may have a situation where I say the class characteristics all agree, and I have some agreement of the individual characteristics, but it's just insufficient for me to say it's an identification. On the opposite end, so to speak, I may have a fired bullet that has all the same class characteristics as the gun, but I'm seeing some differences in the individual. But there could be an explanation for that. I'm just not sure, so I could say that it's inconclusive. I'm seeing some differences in individual, but insufficient to actually say it's an elimination. And then the in-between, inconclusive, would be I'm really not seeing, again, you'd have to have agreement of the class characteristics. Then you would say, I'm really not seeing an agreement or a disagreement of the individual characteristics. Either there's not enough there, maybe the evidence bullet just had too much damage, or it could be that the firearm itself just didn't produce very many individual markings, that you would just say, there's no agreement, there's no disagreement, it's just inconclusive. And of course, the wording is more formal on the report, but simply put, that's what the inconclusive answers would be. So basically 3 different levels to say.
All right, so identification, inconclusive with the 3 kind of classes, I guess, within that.
Yes.
And then elimination. Is there any other conclusion that could be reached on this?
Actually, there is. If an item of evidence comes in and it's unsuitable, that is also a result. An easy explanation to give you for that would be if I receive the core of a fired bullet, based on the bullet core alone, there's really not much I can say about it, so I would say that that item is unsuitable for microscopic comparison.
All right. And you had already determined that item 32 was suitable for comparison, right?
That it was likely suitable, how I stated that, suitable pending submission of something to compare it to.
Right, thank you. All right, so once you test fired, found out what the class, well, you knew what the class characteristics were, you had those test fires, you compared them then to the evidence bullet, is that right?
I stated earlier, I first looked at the test to test, and then yes, after that, I compared the test fire that I made to the evidence that I had previously examined a couple months earlier.
All right, so let's get to your conclusion. What was your conclusion about whether item 44, the rifle, fired item 32?
Based on my examination and using the comparison microscope, I was able to determine that the rifle, item 44, did fire the bullet, item 32.
And was that later verified, that identification, was it verified in your lab?
Yes, it was verified by one of my coworkers.
And confirmed the same thing?
Yes, he did confirm that it was an identification that I had made.
All right. May I have a moment, Judge?
Thank you. Mr. Griffin?
Good afternoon.
I noticed that in your testimony earlier today, when we were talking about the issue of maybe bias, confirmation bias, you talked about how it's important to not receive information ahead of time that might somehow color your judgment. Is that fair?
It would depend on the type of information. Sometimes I receive information that's in a memo of some sort that's not necessarily intended for me. I may read it, I may not, but generally speaking, it is important to maintain an appearance of being non-biased.
In the abstract, in this case, did you receive anything ahead of time that told you what law enforcement was thinking?
Other than the fact that they submitted this particular rifle, it did have the same class characteristics and was one of the rifles listed on that GRC list, I don't believe I was aware of anything further than they wanted it compared to the fired bullet that I had previously examined.
It would be a fair assumption for a professional in your circumstance to certainly think that that's what law enforcement was looking for, whether it was a match, right?
I hope they were looking for the actual rifle that fired that bullet, I can't speak for what they were hoping or anything other than that.
It's important, as you said in your testimony, to be careful about appearances. You wouldn't want to have a look that was not good. Remember when you said that?
Yes,
Now, professionalism matters to you, does it not?
yes, it does.
Professionalism could affect the confidence of your opinions from some people's perspectives, couldn't it?
I suppose it could.
And you pride yourself in not only your performance, but your professionalism?
Yes, sir.
Were you aware of an incident that occurred earlier today that raised questions about professionalism?
I can't say that I know for certain what the incident was or how it came about, but yes, obviously I became aware that something had occurred.
So what occurred, just to summarize, was that a cartridge, meaning the casing and the bullet, and a separate bullet got placed in the courtroom at the witness stand without court knowledge or permission. Are you aware of that?
I was aware that that item or what you described was in the courtroom. At the time, I did not know how it appeared or how it came to be in the courtroom.
But you had questions about the appearance of that situation, did you not?
I believe I was asked, I don't recall, so I can't say it that way. I have concern about the appearances that happen, and I think if I had more knowledge prior to being asked about it, my answer earlier may have been different. I'm not sure if I'm making sense. I apologize for that.
It's all right. So we just want to make sure we're clear. Did you learn last night that somebody might want to provide you with that material today?
Yes.
And did you decide that it might not be a good look for you to receive that directly at the courthouse?
I thought if it were handled with people other than myself and the person providing it, if there were an intermediary person, that would probably be a better thing, since it would be at the courthouse. If he had been in the lab with me yesterday afternoon and provided it to me, it would be something that I could have done myself as well. So as far as bringing something into the courtroom that I just received from someone outside the courtroom, I don't know if that would have been a good thing or a bad thing, but in my mind, I thought it would be best not to receive something directly from someone else outside the courtroom.
It's a thing that certainly you haven't had happen before, correct?
It's nothing that I can recall, correct?
It was unique, and just to be clear, before you were set to come in and take the stand, you received information from that third party that information had been deposited up at the court witness stand. Is that correct?
After I was questioned earlier this morning, I rethought and double-checked what I had stated, that I was not certain of what had transpired, and I was not told who or how that got into the courtroom, just that it was at the witness stand.
Well, and that's unorthodox, unusual, and questions professionalism, doesn't it?
I wasn't told who brought it into the courtroom and who placed it on the witness stand, so I guess I assumed it was done in whatever way would be proper. And again, I can't say what the proper way is because I've not had that situation.
One thing and we'll leave this topic, but one thing we know for sure is that you didn't put a stop to that, did you?
No, sir.
You didn't call it to the court's attention, did you?
If I had noticed
No. Did you call it to the court's attention?
prior to being asked about it, there was,
You not answer it, yes or no?
to the extent of what I knew at the time I knew it, I did not bring it to anybody's attention.
Thank you. So when we're talking about professionalism, let's spin to performance for a minute. You testified previously this morning that not only are your, when you have an ID or an elimination, that there's verification, but you also indicated that your results, to your statement, your results have not been previously inconsistent with another professional's conclusion. Is that what you testified to? Other than the one case that was a work in progress that the person misread what the deal was?
To the best of my knowledge, I don't recall ever having my finalized work be questioned.
Did you participate in any work in connection with the 2015 case, State versus Leslie Merritt?
After the work was done, at a later date, I did.
All right, so is it fair to say that in connection with that case was a highly publicized, big deal in Phoenix? That's the freeway shooter case, correct?
Yes, it was known as the I-10 freeway shooter case.
And that's the guy that was sniping motorists as they were driving on the freeway, correct?
That's what they were alleging in the newspapers and in the news, yes.
You were not the preliminary or the primary examiner to make a determination about what bullet was fired from what gun in that case. Is that fair?
That's correct.
You also were called in to verify the work of another in your office. Isn't that also true?
At the time the examination was done and the identifications were made, I was not the person that did the verifications at that time.
Are you saying that you never verified that?
At a later date, after the reports were submitted, and I believe it was the following, oh boy,
I'm not so concerned about the chronology, ma'am.
okay.
And we don't need to dance on that. Let's just talk about, did you or did you not look at the results and verify the results of your office?
I didn't necessarily verify them because the primary examiner had medical issues. I wanted to look at the evidence and the reports and be able to provide additional information or additional documentation to aid our higher up command to show them what the primary examiner did, why he did it, and explain how he came to those conclusions.
Well, the primary examiner was Christopher Kalkowski, was it not?
Yes.
Right. Did you ever issue an opinion that said that Mr. Kalkowski was wrong?
I did not.
In other words, you backed up his conclusion, did you not?
I can't say I backed up his conclusion. When I looked at the evidence for myself, what I saw looking at the evidence as well as the test fires with the comparison microscope, in my opinion, I did come to the same conclusion.
How's that different than a verification?
A verification would be after the original examiner does their work, then the verifier will come in and verify that what the examiner said is correct. There was no question as to, I was not verifying anything that had already been done. I was just basically reproducing it so that if Mr. Kalkowski, for some reason, couldn't testify or couldn't do any further work on that case, that I would be basically up to par and be able to speak in my own words instead of saying, based on Mr. Kalkowski's analysis, and instead of reading from his notes and report, because it was such a big case, I felt it was important that I knew firsthand what he knew firsthand so that I could speak with my own words and my own opinions and not just have to refer to what had been done.
Mr. Kalkowski determined that there was a match between the question gun and the evidence bullet. Isn't that true?
There was one item that he reported out as inconclusive. However, the other items he did identify back to the gun. You confirmed in your own independent work and you agreed with that. Is that right? I did, in my own work, end up agreeing with his conclusions. Additionally, the item that he had called inconclusive at the time, I was able to identify that to that same firearm that was submitted, and then additionally had someone else verify that portion of the exam.
All right, so you don't disagree with me that your name is involved professionally with the analytical work that was done in that case, correct?
It is now, that's correct.
That's right. And you don't disagree with me that multiple other experts were called to review and examine the conclusions that Kalkowski and you reached. Isn't that true?
I am aware of that. I believe those were done prior to my having looked at it. So at that point, it would have been Mr. Kalkowski's work.
Right. So, but you're inextricably linked to Kalkowski's work because you independently examined and agreed to it. You're prepared to back him up. If he died in a car wreck Tuesday, you would have come in and given your opinion, right?
Again, I wouldn't say backing him up. Based on the work that I did, I would have the same result and the same conclusion as he had already stated, yes.
In my interview with you, I asked you, did I not, about about this topic, and you indicated to me, I've not been in a position where I've had anyone disagree with my work. You recall that?
Yes.
Right. Well, this is that situation, is it not? Because isn't it true that more than one expert, not just one expert, but more than one expert disagreed with the conclusion you reached?
At the time the other experts had looked at the evidence and looked at Mr. Kalkowski's work, I had not seen any of the evidence firsthand working on it for myself. So at the time they made their conclusions, I had not been involved in that case as far as literally working it. I had just been present in the lab when Mr. Kalkowski worked it, and I knew what was going on. So at that point, I could say that no one had disagreed with me because I hadn't done anything yet in that case.
Well, you know that now that there is a disagreement between your conclusion and conclusions reached by other experts, do you not?
Their conclusion was different, but I can't say that they stated that Mr. Kalkowski did anything wrong, or then in turn that I had done anything wrong at a later date.
That's not really the technical term, is it? There's a difference of opinion. It's not whether somebody did something right or wrong, correct?
You are, yes, you're more correct saying it that way. I
Let me
apologize.
make sure I'm also clear, because in our interview, did I not ask you to name an authoritative source in the field, a private practitioner, if you will, that you had high respect for?
You did ask.
And one of those people was Lucien Haig, was it not?
Yes.
One of the people that disagreed with your findings in the Leslie Merritt case was Lucien Haig, the person that you indicate top shelf guy, right?
In different areas and different parts of firearm identification, I still have high regards for him. When it comes to microscopic work, I would not feel as comfortable with his work on the microscope as someone that I know that's been doing it regularly, more day to day and on a regular basis.
So when you told me you had high respect for his work, you didn't condition it on something else. You didn't know at that point in time that I'd researched the Leslie Merritt case and knew what I knew, right?
Correct.
Right. So Lucien Haig's fine until I call it to question that you said he's a great examiner, and then I point out to you that he has an opposite conclusion in the Merritt case than you did, right?
Again, I would state that he's a great examiner in certain areas of the field, and some of the work he does, I don't do, to be honest, and he probably knows more than I may ever know about different firearms and where they're from and other areas. But when it comes to the actual microscope work, because someone may not have the experience and the continued experience as I do, I don't want to negate the rest of the things that I believe that they are extremely qualified for and well known for.
Well, let's accept your rather lengthy answer that somehow this was a blip and that Mr. Haig didn't get it right. Is that what you're trying to tell me?
If I can use Mr. Haig's own words, he even had the opinion that he probably shouldn't have taken this case and that his eyes were getting old.
Well,
To use his own words.
he backed up his opinion and professionally supported it, and it was inconsistent with yours. You agree with that, don't you?
That was
Yes or
his
yes or
result.
no?
Yes.
You agree with that. And so, because this was such a, if you will, a high-profile case, and this issue could be outcome determinative of what happened in the case, it was not only referred to Mr. Haig for a second opinion, but to another agency to examine further and get an additional opinion. Isn't that true?
It was.
Yeah. So it went to the Bureau of Alcohol, Tobacco, and Firearms, did it not?
It did.
And they do professional examinations. That's part of what they do, is it not?
They are an accredited laboratory, so I would agree with that, yes.
They have a blip problem too and just come up with the wrong answer, because didn't they come up with the same answer that Mr. Haig did that was inconsistent with your answer?
The examiner that worked that case had that evidence for approximately 24 hours, and I know that Mr. Kalkowski had different parts of the evidence they were listed under different DR numbers, department record numbers. He had been seeing parts of that evidence for, I believe it was a few weeks. He became very familiar with what he was looking for, and he had made identifications between fired evidence from the different scenes prior to a firearm ever being submitted, when I saw that the examiner at the ATF only had the evidence for a 24-hour period of time, I really was not surprised of the conclusion he made based on the amount of time he had to work with the evidence and look at the
Is
evidence.
it possible that you could articulate to us, can the words fall out of your mouth, that he disagreed with you? Can you just say that?
He disagreed with us.
Thank you. And you're saying that it was because he didn't spend enough time, he wasn't thorough enough, therefore he couldn't have gotten it right. Is that correct?
For this particular instance that I'm aware of, the things that happened, I would agree with that. He did not have enough time to spend looking at the items of evidence with the microscope.
So when we come full circle and we come around, I've just pointed out to you two professional people who disagreed with your opinion in direct contravention to what you testified to this jury and what you told me in your interview. Yes or no?
At the time of that disagreement, it had not been my opinion. It was a later date I stated that I looked at it for myself and I agreed with Mr. Kalkowski. Hindsight, that means that they would have disagreed with me, but indirectly.
So you told us that professionalism matters, right?
Yes,
And so in your performance, you talked about how you go about the process of first examining the weapon, determine its characteristics, class characteristics, operable condition, all of that, right?
yes,
And then it takes time, does it not, to then do the analytical work regarding examination and comparison, does it not?
yes,
All right. And the skill, background, qualifications of that person are certainly important, right?
I believe so, yes.
You would tell us that despite people have disagreed with you in the past, as we've now established, you think you have that skill set, right?
I do.
All right. And would you tell the jury exactly how much time you spent doing your analytical comparison work with the evidence bullet and the test fires in this case?
I can tell you the dates that I actually had the evidence in front of me. As far as the number of hours, I would not be able to give you that answer. It was, I know I had the evidence, the test fires, and the fired bullet for more than just one day. If you would like me to refer to my chain of custody, I can tell you how many days it was in my possession, and that may give an idea of how long I worked on it.
I've had Mr. Gooch's case for a year. That doesn't tell me how much time I've spent on it. You had this case for a period of time. I understand you had it in your inventory. What I want you to tell the jury is how much time did you spend analytically doing the comparison work? 1 hour, 10 hours? Because I think I know the answer. Why don't you tell me?
I don't recall. I would say minimally several hours. It took as long as I was comfortable with seeing a reproduction of individual characteristics when I looked at the test fires to each other. And when I compared the evidence bullet to those test fires, I took as much time as I needed to ensure that I saw a reproduction of the characteristics that I felt there was sufficient agreement for an identification.
Is your lab backed up?
Could you please explain what your...
Lab backed up. You got work stacked up waiting to get to?
These days, we don't have a very big backlog at all,
You have a
as far as the firearm section is concerned.
You have a backlog.
I believe the last time I looked at the pending cases, maybe between 6 and 10.
All right. You had a backlog back when you did this work?
I don't recall if there had been a big backlog, but it's been a while since we've had a substantial backlog, like many years.
You have to meet proficiency standards in terms of production?
We are expected to complete work and show that we are working, whether it be on casework and evidence items. There may be other things in the laboratory that need to be done, which would include any mandatory training throughout the year. I'm required to justify how I spend my time in the lab, whether it be on casework or non-casework type duties.
Translation, are you required to crank them out?
No.
Okay, so let's go back to the substantive quantitative question here. If I told you that I think, looking at your material, you looked at this material for 2.5 hours, you agree or disagree?
looking at all of this, I think I would have to disagree.
Well, is it recorded in your materials as to when you looked at the stuff and did the comparison work?
What is recorded, which is why I can't state exactly how many hours, is the start date of when I was looking at the items of evidence. That also has an end date, and then my report will have another date, along with the chain of custody, which would show when I received the evidence and when I returned it.
You agree with me that you could have spent 2.5 hours or less in the comparative work on this case, yes or no?
I suppose that's possible.
And you talked about, and you explained over and over again, because you are a veteran examiner, how experience matters, right?
Yes.
And is it possible that an experienced examiner like yourself could reach a knee-jerk conclusion without being as thorough as perhaps you professionally should have been?
Personally, I would not do that.
But are you saying
Actually,
that-
could you please explain what you mean when you say knee-jerk? I know generally speaking what the term means, but in this
Saying you
type of
came
situation.
to a rapid conclusion without going through all of the painstaking process that maybe you would have done 15 years ago as a young and upcomer.
I actually would probably do more now, knowing more, than maybe in the past. And it's my work that I'm producing, so I'm always going to have the same quality of examination and work in my product as what I feel comfortable with back then, now, and in the future.
All right. Now, should I just take your word that there was a match?
You can do that, or you can rely on the fact that my work is verified and then recount the different things we had covered earlier today about the quality assurance and the different procedures that are followed in our laboratory.
Do you have material that you can show this jury today, how you came to the conclusion that you did?
For this specific case, I have the notes that I produced while I was working the case. There are photographs in my notes. I would have to admit they're not the greatest quality. I believe that looking through the microscope is where you'll see what I see the best. Anything after that, whether it be on a computer screen or a saved file or a printed copy, will not even compare to the quality of what I see on the microscope. So to see what I did and how I did it, you would have to refer to my notes and my report for this and every other case.
Do you think it would be fair to a juror in a situation like this that they could actually see what you're saying and compare it to with their own eyes, whether they agree with you or not? I mean, why didn't you bring something for us to look at today?
As far as demonstrative materials,
As far as being able to show us where you compared the class characteristics and the unique individual characteristics, and show us why you came to your conclusion with objective, taking a look at it stuff.
the images that were shown earlier today to assist in describing what rifling is, I maybe have a 3D version, not maybe, I do have a 3D version of that. I don't typically bring demonstratives to court. I do my best to use my words to explain and describe what I'm looking at. Other than the pictures that were shown where you could see the defects in that hammer, for instance, it would be very hard for me to take a photo or to show you what I'm looking at on the microscope and expect an untrained eye to see exactly what it is I'm looking at that I use to form my opinion. I think that's the best way I can answer your question.
When I interviewed you, didn't I say to you that I had looked at your comparison photographs and said I can't see very clearly what's going on here? Didn't we have that discussion?
Yes.
Didn't you tell me that, well, and I even said, should I just take your word for it, or should you be able to show me? Didn't I say that?
I believe, if not that, something along those lines, yes.
Didn't you tell me that, yeah, it's all about being able to examine it physically with the microscope? Photographs don't do it. In fact, you told us today, photographs don't do it.
Yes.
Yet you didn't even bring us photographs, right? I mean, I don't need a photograph of a hammer, right?
My understanding, and I may be wrong, I don't bring new stuff into court myself. If I'm asked about my notes in my report, it's going to be what has already been released to the agency and then submitted in court. I if I were specifically asked to reprint or somehow bring a computer file of those photos, I could have done that. But I thought it best, or my practice is to just bring what has already been introduced and not provide anything additional with my work that hasn't been seen before.
Okay, well, and I guess in any old run-of-the-mill case where wasn't much at stake, we could just take your word for it, you wouldn't have to show us. But even in this case, you acknowledged from the get-go that, when you talked about suitability for comparison, I mean, you had to qualify suitability. This case wasn't clear. This evidence bullet was damaged significantly. You agree with that, do you not?
May I state first, please, any case I work, I don't always necessarily know what any charges are, and I'm always on the line when I testify. So I treat every case the same as far as the quality of work I'm going to put out, no matter what type of evidence or what or who's involved.
I appreciate all of that explanation, but answer my question, please. Wasn't it a questionable suitability situation? Yes or no?
It was not questionable suitability. I just did not want, I stated in my report initially, suitable pending the submission of additional evidence. I felt that there were individual markings there that I could use for comparison purposes, which meant it was suitable. And with additional evidence, that's something that I could compare it to.
Doesn't damage enter into the equation with the evidence bullet?
Evidence bullets can come in damaged very often, and yes, that could
Of course,
make a
and
difference.
the quantity and the nature of the damage can affect your ability to make appropriate examination. That's the whole suitability argument, right? It's a threshold.
I don't know I can describe it as a threshold, but if a bullet is, any damage done to that bullet will affect what I'm able to see on it.
I thought you told us, I'm sorry, go ahead.
And what is undamaged, what I can see, if I'm doing a comparison, no matter how much of the bullet I can or cannot see, I still need to see a sufficient agreement of those individual characteristics before making an identification.
I thought we came to the conclusion, tell me if I'm wrong, that if you have an unsuitable evidence bullet, that's the end of the day, right? I mean, that's as far as you can go. You don't have class or individual characteristics sufficient to be able to continue the process, right?
With unsuitable,
Right.
that's correct. I would be saying there's no reason to go further. This is unsuitable.
What you said in your evaluation regarding suitability was it may be suitable because there's a lot of damage here. You agree with that, right?
And I would have to say that's different than unsuitable.
Well, I understand that, but what I'm asking you to acknowledge to the jury is that this wasn't a situation where we had a pristine bullet. We have a highly damaged bullet. We've seen the bullet. The bullet's in evidence. You've seen the bullet. Don't you agree that it's highly damaged?
It was quite damaged. It definitely was not a pristine bullet.
And we agree that the quantity of damage can affect the ability to make conclusions, correct?
Yes.
Right. So I haven't heard you say today, talk about striae. What are striae?
Stria is the word that's used to describe those markings made by the individuality of that barrel. As the bullet travels down the barrel, the marks are scratched into that bullet and striations are made, so stria or scratches. Those are the markings that I'm looking at that are the individual markings.
Right, and so you haven't talked about that at all today. So why don't you tell the jury how many stria matched up here today, what the standard is for that, so that we can come to a conclusion as to what you found. How would that help us, wouldn't it?
Well, there is no standard for counting stria, and there is no reference as to how many stria need to be counted in order to make an identification. I'm looking at a pattern of markings, and I want to see a sufficient reproduction of those patterns of markings, and those patterns are made by the striations or those scratch marks that are imparted upon that bullet as it leaves the barrel.
Well, let me see if I understand this correctly. From an industry standard, and you've talked about the industry that you're a member of. That's the governing body, if you will, that sets standards and that kind of thing. Are you telling me that there is no set standard as to how I determine the validity of your conclusion compared to another examiner?
Some examiners do use another method as a tool in the process of doing their work. And if you're speaking of, it's known as CMS, consecutively matching stria. And in that manner of doing things, an examiner would count the number of stria that consecutively match in a row. I don't recall what their standards are or their threshold for the count. However, it's just a tool that's used to attempt to quantify what I'm looking at. In the end, it is the reproduction of the pattern that I'm seeing, and it is not a generally accepted standard. It's just another tool that can be used in the process of doing an examination.
Well, maybe consider me an inquisitive guy, but if you said it's a match, and I challenge you on that regard, and I'm asking you to tell this jury, why is it a match? How many stria were there? Do you have CMS? What do you have? Please tell us what you have.
I will admit it is difficult for me to explain. It's difficult for anyone to explain what they're looking at when they're trying to describe reproduction of patterns. I think the best I can say is that the stria I'm looking at are of a quality and a quantity to be similar to known identifications that I've made in the past. For instance, looking at a test to test. And when I'm doing comparisons with unknowns to test fires or unknown to unknown, I want to be sure that I'm seeing more agreement than what I would expect to see in tool marks that may have been made by different tools. And I want to see at least a consistent agreement in what I've seen when I'm looking at tool marks to be known to have been made by the same tool.
Well, so you explained that there's different conclusions based upon what you see. You can have an identification, inconclusive, an elimination, unsuitability, and you told us that within that, you could have a situation where you have general class characteristics that match up, and then you could have some striae that look to be in agreement, but some striae look not to be in agreement, right?
That could happen.
Well, tell us what happened here.
That did not happen in this instance. The stria that I was looking at was in agreement with my test fires. Of course, the areas that were damaged were just damaged and no longer had that stria that would have come from the firearm. In a sense, it was wiped away, for a simple way to describe that. So the stria that was present and that initially appeared that it could be suitable was suitable, and there was sufficient agreement of that stria, of those patterns, from the evidence bullet to my test fires, that I made my conclusion as my result was identification.
So you can't tell us numerically, you can just tell us essentially, I came to this conclusion, I didn't show you why, I can't show you why, I can't give you a numerical count. I acknowledge that there was damage that affected the amount of striae and the amount of comparative stuff that's there. I don't think there was any disagreement. That's what you're telling me. Is that right?
Well, there is no numerical value I could even give you.
Let me ask you about that. So is that a fault of your industry?
I don't feel so.
No, do you not know that there's a push to try to get some sort of standard in place so that we don't have this issue?
Yes, the push is there, but nothing's been provided that accounts for what we do when we say pattern matching. And I apologize for not having a better way of stating this at this point. To put a numerical value on what I'm looking at, if I were to use an analogy of cars, I have a Kia Sportage that's silver, and many times there's another Kia Sportage in a parking lot that if I forget where I park, which happens, first I narrow it down, it's a Kia, it's a Sportage, it's silver. When I see the slight dent that I unfortunately put in my front fender, then I know that's mine. That's an individual characteristic. I can't put a numerical value to that slight dent that I see in my car. And it's a very similar, I hope you can understand that analogy, but it's pretty much just like that. I can give you the class characteristics, the caliber, the rifling, and after that, I've got to look for those individual things that aren't numerically countable, but I'm just seeing the reproduction from one to the other with a sufficient amount of agreement that based on my training and my experience and the things I've seen over these 26 years, that what I saw here was consistent with any other identifications I've made, whether they be test to test or test to evidence, that my opinion here was that it was an identification.
Which is like in the Merritt case that we were talking about, where you came to that conclusion that something was a match, whereas two other highly regarded examiners came to the opposite conclusion, right?
They are highly regarded, but the ATF examiner, I cannot state if I know how long, or I'm sorry, I cannot say how much time he spends on the microscope. What I can say is he did not have that evidence for long.
All right, well,
With Mr. Haig, I know he does not spend a lot of time on the microscope these days, and I think that mattered.
well, and if we're questioning you about the amount of time you spent, you would agree it matters, right?
I would have to say those are two different things. The fired evidence from the Merritt case, I'd say was based on the type of gun that was used and the ammunition that was used, was more challenging to look at, as well as the deformity of those fragments that we looked at. So that is going to make a difference as well.
Well, let's do this. So the Merritt case went south in part because of the failure of the conclusion about the evidence, about the firing, right? You don't dispute that, do you?
Of whose conclusion?
Case was dismissed, right?
That was the county attorney's decision,
Right.
and I don't
Because in
know, I
part-
can't say I know why.
Well, you know, at least in part because of the problem with the evidence in your analysis, right?
I can't state why they actually dismissed it.
No, I guess we'll just assume it must have been for some other reason. But let me ask you this. So let's analogize your industry to the fingerprint industry, all right? Does the fingerprint industry have this same subjective issue that we're dealing with right now in this case?
I'm not,
Differently, is there a standard in the fingerprint industry as to when you can conclusively say something's a match?
I would have to say I don't know. They do comparisons like we do. I don't know what their threshold is. I don't know how they verbalize their results and how they got there. Yes, of course, I know it's questioned, and I know years and years ago that the number of points mattered, and then I believe that went away. I don't have enough knowledge with how Latent Prints examines their evidence and how they base their opinions. I really can't speak for that.
So we're left with the subject, we'll just leave it at this. So let me ask you this question. So are there indications in your notes that you struggled to look at this stuff and get consistency or to find conclusive evidence one way or the other?
I don't believe so. If I'm remembering correctly, my notes basically state the characteristics of that fired bullet, and
Aren't there some colored dots and markings on your bullets that suggest that perhaps there was some concern by you?
I do use colored Sharpie markers to mark my test fires as well as the evidence, and that just indicates to me if I have numerous items of evidence, or in this case, the 3 test fires, when I'm looking at test to test, I'll typically mark or index those bullets so that, especially with 16 lands and grooves on a small 22 caliber, to indicate where I looked at something and where I thought that something might be matching up. And then I'll do the same when I put the evidence on the microscope. And if I think I have the red dot here on my test fire, and lining that up with this area on the evidence bullet, it looks like I'm in the same area, I'll put a red dot on the evidence bullet. I will use those types of markings for indicators to myself so I know where to look when I come back to the evidence and look at it again. And again, with 16 lands and grooves on that small 22 caliber, the ink does tend to bleed and run a little bit. So if I were to give someone these items and say, just go to the red dot, you'll find it, they'd probably say, well, that red dot covers a couple different areas. Which is it? So yes, I do have those indicators. And in this instance, they can be confusing if you were to look at it and not know what I just explained.
Is it important that you stay up with the most current publications and things that are going on in your industry?
Yes,
You do that?
I do my best to do that, yes.
Are you aware of using any out-of-date material in connection with the examination in this case?
I was brought to my attention of one particular thing. And that was the GRC list, the general rifling characteristics list that I provided in the database I used.
How did that come to your attention?
I was made aware that a comment was made that I believe the comment was I used an older database.
An out-of-date database.
That's more like an out-of-date database, yes.
That came as a result of knowledge about what our expert determined, right?
Yes.
Right. You agree that you used the wrong database.
No, it was not a wrong database, it was just a different database.
It's out of date.
It was still valid.
Wasn't the most recent.
There was something available that was more recent, but again, mine was still valid.
Was that an oversight on your part? Are you not staying up with what's going on?
I don't think so. The list that I used, which listed numerous firearms, I also state in my report that that list may not be all-inclusive, and any suspect firearm should be submitted.
You would agree, or let me rephrase it this way. Would you say here that the evidence bullet and the test fires, could the evidence bullet be included or excluded from the 22 Marlin?
I'm sorry, could you restate that?
I want you to tell me whether or not the evidence bullet could be excluded or identified as having come from Gooch's gun.
I could state that the fired bullet was identified as having come from the firearm that I received as item 44. Am I missing something in your question?
I want to make sure that in your compendium of conclusions, that what you're telling us is that you have an identification. You don't have inconclusive, you don't have any other problems, you're not in the insufficient area, the no agreement, disagreement, insufficient to eliminate part of the conclusive strata. You are saying that this was an identification. Is that right?
That's correct.
Thank you. No further.
So will you, please? Just came in. Came in a minute ago. So we're going to go ahead and take our break right now. One of the jurors needs to call home, so to speak, and the note was just passed me just in the last couple minutes, probably a minute or so before Mr. Griffin just finished his cross-examination. So I'm going to speak to this juror in just a moment. Ladies and gentlemen of the jury, so we're just going to take our afternoon recess a little bit early, okay? And we'll bring everyone back in when we're all ready to do that. Remember the admonition. Please keep an open mind about the case. Do not formulate any position about the case. Do not talk to anyone about the case. Do not let anyone talk to you about it. And that includes each other. Can them remain? Who's Joe? I'm sorry, I don't have my seating chart. Okay, if you'll just remain in the courtroom, please. Could you just remain in the courtroom? Everyone else, go ahead and start the recess. You can.